My name is Dave Douglas. It's my pleasure to serve as Dean of the Law School here at William & Mary, and it is my great pleasure to welcome you to this conference on the Civil Jury as Political Institution, which is our annual law review conference for the current academic year. And of course, the papers of this conference will be published next year in the William & Mary Law Review. As it happens, I love biography. And last night, I was reading a biography of a jurist who I think was arguably the greatest proponent of the jury in American history. And that was the first Justice John Marshall Harlan. Harlan, of course, during his time on the court, was the strongest proponent of a constitutional right to a jury trial, federal court, state court, in the territories acquired after the Spanish-American War. As a law professor, and he taught law for 20 years, constitutional law for 20 years at George Washington, Harlan would wax eloquent to his students about the centrality of the jury system to the American political and constitutional system. For Harlan, the jury was nothing less than a sacred institution. He told his students that I believe there is no feature of Anglo-Saxon civilization today that lies more nearly to the liberty of man than the right of trial by the old-fashioned jury composed of 12 honest men, and I would not dispense with any feature of that system. Now, Harlan was a great student of American politics. Both political parties sought him as a presidential contender during his time on the court. He worried about American politics. He worried about the nefarious influence of money in politics, particularly in state legislatures charged with selecting United States senators. He also worried about the fact that so many Western states were extending the right to vote to non-citizens who had just arrived in the United States, trying to attract them to reside in Western states and territories. But Harlan took comfort in one thing, and that was this. At the bedrock of our political system was the American jury, and the common wisdom of jurors would be that which would keep America moving in the right direction. And so Justice Harlan, we've just recognized the 100th anniversary of his death a couple of years ago, I think would be very pleased with this conference. Now, we have two distinguished guests to lead off with this initial session, and each will speak for about 20 minutes, and then we'll take questions from the audience. We're very honored to have with us Senator Sheldon Whitehouse of Rhode Island. Senator Whitehouse is a graduate of Yale University and a graduate of the University of Virginia Law School. Before being elected to the United States Senate, he served in a number of prominent posts in the state of Rhode Island, including as United States Attorney for Rhode Island and also as Attorney General of Rhode Island. In 2006, he won election to the U.S. Senate and was reelected just in 2012. Among his committee assignments, of course, he serves on the Senate Judiciary Committee and currently serves as chair of that committee's subcommittee on crime and terrorism. He's also, among a number of other things, has sponsored legislation to repeal the Defense of Marriage Act. Senator Whitehouse, welcome to the nation's oldest law school.
Thank you, Dean. Thank you, Dean Douglas, and thank you, Professor Solomon. And I'm honored to join my friend Akil Amar and all of you for this wonderful discussion. It gives me great pride to be here at the nation's oldest law school, dating back to 1780, when none other than Thomas Jefferson prompted the college's Board of Visitors to let his mentor, George Witt, begin teaching law at the college. He taught the future Chief Justice of the United States, John Marshall. He taught James Monroe. He taught Henry Clay. He had taught Thomas Jefferson. So to those of you who are students here today, no pressure. This law school, although the nation's oldest, is still young compared to the civil jury. Scholars have documented, for example, that by 1624, 156 years before Witt's appointment and 69 years before the founding of this college, juries were available for all civil and criminal cases here in Virginia. The civil jury has, of course, been a bastion of individual rights throughout a long history. But it is more than that. It is also a structural element of our unique American system of government. It is part of our constitutional design of separated powers. That's why this symposium on the civil jury as a political institution matters. And that's why I want to discuss three topics today: the historical importance of the civil jury, the contemporary undermining of the civil jury, and how to protect the civil jury as an element of our system of government. Let's start with some history. Elements of our jury system can be traced back to 12th century England, when Henry II transformed the jury from an administrative body into an instrument of justice. By the 1760s, Sir William Blackstone extolled the trial by jury as the, quote, glory of English law. Blackstone understood the civil jury to be a political institution. He explained, I'll read his quote, "The most powerful individual in the state will be cautious of committing any flagrant invasion of another's right when he knows that the fact of his oppression must be examined and decided by 12 indifferent men." You'll have to forgive the gender issue. It was 1760. 12 indifferent men not appointed till the hour of trial. And that when once the fact is ascertained, the law must, of course, redress it. This, therefore, preserves in the hands of the people that share which they ought to have in the administration of public justice and prevents the encroachment of the more powerful and wealthy citizens. Not bad. The earliest American settlers likewise understood the importance of the jury. In addition to Virginia in 1624, juries were established in 1628 in the Massachusetts Bay Colony, 1677 in the colony of West New Jersey, and 1682 in Pennsylvania. Well before American independence, the civil jury provided Americans a mechanism for participating in their government. Colonial Americans attacked British efforts to curtail the jury in the 1760s and 1770s. In response to the Stamp Act, for instance, colonists declared that, quote, trial by jury is the inherent and invaluable right of every British subject in these colonies. The 1776 Virginia Declaration of Rights provided, quote, that in controversies respecting property and in suits between man and man, once again I apologize, the ancient trial by jury is preferable to any other and ought to be held, to quote Harlan's word, sacred. And of course, here in Virginia, we have to cite Mr. Jefferson's Declaration of Independence, which complained of the king, quote, depriving us in many cases of the benefits of trial by jury. As Blackstone said, the civil jury, quote, preserves in the hands of the people that share which they ought to have in the administration of public justice. Colonial Americans prized that rightful power, as did the drafters of state constitutions. 10 states included provisions protecting the civil jury in their early constitutions or bills of rights, establishing the civil jury as another structural element of government consistent with the Locke and Montesquieu vision of separated powers. When the original federal Constitution was silent on the civil jury, Americans reacted with alarm, fearing that the Constitution, quote, effectually abolished the right to a civil jury. The pamphleteer, calling himself a Democratic Federalist, urged his fellow citizens to, quote, never consent to part with the glorious privilege of trial by jury, but with your lives. Federalists were quick to try to reassure that the Constitution would not deprive anyone of access to the civil jury. The differing forms of trial by jury in the various states, they said, made inclusion of any single form of civil jury in the federal Constitution impractical. Legislation would sort out the details. Americans would have none of it. By August 1788, 5 of the 13 ratifying conventions already had demanded greater civil jury safeguards, and the Bill of Rights was sent to the states with the 7th Amendment. which would protect the civil jury. James Madison, who once doubted the need for a Bill of Rights, supported this amendment, stating that, quote, trial by jury in civil cases is as essential to secure the liberty of the people as any one of the pre-existent rights of nature. Alexis de Tocqueville did his wander around America, wrote it up, and half a century later agreed, calling the jury an institution of government and, quote, a mode of the sovereignty of the people. So we can see that the civil jury was understood from its very beginnings in England as a mechanism for the people to exercise an element of sovereign power and to defend themselves against power and influence. It was a flashpoint in the Revolutionary period for exactly this reason. It was explicitly preserved in the Bill of Rights to serve this political function, and it was clearly recognized as such by de Tocqueville and other students of American politics. So against that historical backdrop, let's turn to the recent Supreme Court decisions that have undermined the civil jury. These decisions relating to arbitration, pleading, class actions, and punitive damages don't actually interpret the Seventh Amendment. In fact, they consistently ignore the civil jury amendment as they busily make it harder for individuals to get to a civil jury and harder for the civil jury to play its intended function in our system of government. One line of recent cases has seen the court expand arbitration in ways that allow powerful commercial interests to divert litigants away from civil juries. The Federal Arbitration Act of 1925 provided procedural guidance to courts applying commercial arbitration agreements, and for a long time the Supreme Court applied that statute narrowly. That has changed. In 2001, the court expanded the Act's coverage of employees engaged in interstate commerce, and in the last 3 years, the court has held that arbitrators may even adjudicate whether their arbitration clause is unconscionable, and has held that mandatory arbitration clauses may entirely prohibit bringing class actions before a jury. As a result, more and more cases are funneled into business-friendly arbitration and away from the civil jury. Supreme Court decisions also added a new element to Federal Rule of Civil Procedure 8A, long understood as providing a simple notice pleading system, intended to focus litigation on the merits of the claim. The court's decisions in Twombly and Iqbal departed from this understanding, deciding that a complaint must state a claim to relief that is plausible on its face, thus making it easier for defendants to use dispositive motions to keep plaintiffs away from a jury. Relatedly, the Roberts Court has made it harder to establish that a class action is appropriate. As a result, injured Americans may have to pursue relief one by one, effectively preventing cases of large-scale but low-amount fraud from ever being brought before a civil jury. Finally, recent Supreme Court decisions have limited the civil jury's traditional authority to impose punitive damages. In the 1990s, the court began to impose both procedural and substantive limits on jury awards in state court cases. In 2008, the court took this concept even further, holding that an award of punitive damages higher than the compensatory damages award would make punitive damages too unpredictable for corporations. The judgment of the jury in the case, its structural role as a mechanism for redress against the powerful, and the historic wisdom of the Founding Fathers as to its role in our constitutional system, all stood for naught compared to providing corporations predictability. The sum total of these cases has been a windfall for corporations that injure Americans, whether that injury may have been caused through deficient products or employee discrimination. This result, of course, has been the intent of organizations such as the U.S. Chamber of Commerce's Institute for Legal Reform and corporate-funded so-called AstroTurf campaigns have pressed this fight in local judicial elections, in state and federal legislatures, and in the court of public opinion. Think about it. Ask Americans to fill in a blank, word of their own choosing, before the word jury. Blank jury. Think how many might come up with the word runaway. Every one that does is a testament to the influence of that campaign. We've slid a long way since the popular outcry for jury trial that our founding fathers knew. Today, the civil jury has fallen precipitously in the esteem of both the public and the Supreme Court, and jury trials are actually the rare exception, not the rule, in American courtrooms. One might even wonder whether we have lost our historic understanding of the political function of the civil jury. We forget our history at our peril. 4 reasons make the civil jury as necessary a part of our constitutional system today as it was back at the birth of our nation. First, the civil jury prevents judicial autocracy. By removing fact determination from the province of the judge, it offsets any bias that may be introduced through the judge's preferences. For this reason, Alexander Hamilton called the civil jury a security against corruption. Second, service on civil juries fosters civic education and engagement. As de Tocqueville wrote, the civil jury, and I quote, should be regarded as a free school, which is always open, and in which each juror learns his rights. Civil jurors are empowered to actually make decisions on the outcome of disputes and the application of laws in their communities. Third, the civil jury brings together Americans of different walks of life. By requiring jurors to be locked in a room together and to reach a reasoned conclusion, jury service strengthens the fabric of our democracy. Fourth and last, the civil jury helps check and distribute power. The American system of government, after all, is built on Montesquieu's and Locke's premise that divided government and separated powers are most protective of individuals' liberties. The civil jury further distributes the authority of the state, vesting citizens, ordinary citizens, with direct and substantial authority to resolve disputes among one another. Not for nothing did the founders reference the jury 3 times in the Constitution and the Bill of Rights. Imagine that you are all alone and unpopular, that all the forces of money and power in society are arrayed against you. Imagine that your adversaries' lobbyists have the legislature tied up in knots and the governor in their pocket. Imagine that the owners of the local press have marshaled public opinion against you. Where do you turn when the power of your community is turned against you? One last sanctuary remains. The hard, square corners of the jury box stand firm against the tide of influence and money. That's why de Tocqueville called the jury an institution of government and a mode of the sovereignty of the people. Not for nothing was the chapter of Democracy in America in which he discussed the civil jury entitled, "On What Tempers the Tyranny of the Majority." The Founding Fathers built safety valves into our system of government. One was a civil jury that allows regular people, people without power, to participate in our decisions. The powerful will always seek to gain influence over levers of government power. That's the story of my current life. Look at the efforts of commercial interests to seek influence over the legislative branch and over the executive branch at both federal and state levels. Through lobbyists, through campaign contributions, and now through super PACs. Is it not a matter of public concern when powerful commercial interests succeed at inhibiting the very institution of government designed exactly to counter their power and influence? The one institution where tampering with the institution is actually a crime? So what can be done? First, the Supreme Court could incorporate the Seventh Amendment against the states. The civil jury would appear to meet the judicial test that it be, quote, deeply rooted in this nation's history and tradition, and, quote, fundamental to our scheme of ordered liberty. That would be a reasonable first step. The Supreme Court also could reconsider, in light of the jury's structural role, the decisions I described previously relating to arbitration, pleading, class actions, and punitive damages. In other areas of constitutional doctrine, the court is far more solicitous. In the First Amendment context, the Supreme Court has struck down otherwise unobjectionable rules that chill the exercise of free speech. Why not, under the Seventh Amendment, strike down rules that chill the ability to reach a civil jury? The Supreme Court has shown great solicitude for the Second Amendment, recently discovering an individual right to bear arms for the purpose of self-defense. The court has not been equally solicitous of the Seventh Amendment or similarly attempted to expand private rights in that context. Finally, in the Fifth and Sixth Amendment context, the Miranda warnings inform an individual of his or her legal rights to avoid unwitting surrender of rights protected by the Constitution. Why not, in the context of the civil jury, prohibit pre-dispute mandatory arbitration clauses without a clear and specific voluntary knowing waiver? Congress, too, can act. Congress could override most, if not all, of the Supreme Court's recent decisions that have undermined the civil jury. Bills to ban mandatory pre-dispute arbitration, to restore notice pleading, to protect class actions, and to enshrine the jury's proper discretion regarding punitive damages all have been introduced in Congress. Unfortunately, it is in the legislative branch where corporate power is at its highest, and corporate interests usually defeat these legislative efforts. Sort of a constitutional irony that we should have to go to the legislature to solve the problem of the juries. The success of the Lilly-Ledbetter Act, which related to the civil justice system, if not to the jury system specifically, provides some hope for those of us championing this fight, but it is an uphill slog. Further, the Senate ought to promote the civil jury's structural role through our judicial confirmation process. Judicial nominees should not be confirmed to the bench thinking that the civil jury is simply an appendage of the court to be managed and diminished. To that end, I've asked recent nominees before the Senate Judiciary Committee, including now Justices Sotomayor and Kagan, about their perspectives on the jury. And at a 2011 hearing on the role of judges under the Constitution, I asked Justice Scalia whether he understood the jury to be a political institution and an important piece of our governmental architecture. He agreed, saying that the jury, quote, is a check on the judges. I think the framers were not willing to trust the judges to find the facts. So the jury absolutely is a structural guarantee of the Constitution, he said. Justice Breyer likewise addressed the structural role of the jury, observing that it brings an entire community into the legal process. Summarizing their two sentiments, Justice Scalia added, I'm a big fan of the jury, and I think our court is too. I hope that history will prove that the court understands the structural importance of the jury. Constitutional text and history establish the civil jury as a political institution within our system of government. And the fact that jury decisions may sometimes be disruptive of commercial expectations is a concept that the Founding Fathers not only would have understood, they likely would have applauded. At our peril, we allow this institution to wither away unheeded and unappreciated. Let's not make that mistake. Thank you very much.
Thank you, Senator Whitehouse, for that very robust defense of the role of the civil jury today. Our next speaker is Akil Amar, Sterling Professor of Law and Political Science at Yale University. As it happens, Professor Amar was a Yale Law College classmate of Senator Whitehouse and then graduated a few years later from Yale Law School, where he was my friend and classmate. After serving as a law clerk for Judge Stephen Breyer, Professor Amar returned to Yale to join the law school faculty in 1985. Professor Amar is one of the most influential constitutional theorists in the United States. The Supreme Court has invoked his work in the course of its decision-making on more than 20 instances. He is the author of several leading books on the American Constitution, including the Bill of Rights, Creation and Reconstruction, America's Constitution, a biography, and most recently, a book that I would recommend particularly for students in the room today, but for everyone, America's Unwritten Constitution, the Precedents and Principles We Lived By. Professor Amar.
It is a very great pleasure and honor to be here with you all back at William and Mary. It's a special treat to follow Senator Whitehouse, especially after it's also a challenge given his extraordinary performance. Dean Douglas, it's always great to see you again, and I can't, I guess, and also special thanks Neil Devins for helping to make this possible. I guess I can't help saying one other thing. As I walked into this building and I noticed the statue of George Witt, a teacher known by, among other things, his extraordinary students, Thomas Jefferson, John Marshall, Henry Clay. Did I mention James Monroe? There are others. As I look out in the audience and survey the schedule, I can't help notice that I too have been blessed over the years with extraordinary students, two of whom you will be hearing from over the course of this event. I love the idea of a law school named for a teacher, celebrating a teacher, and a teacher in part known for his students. So thank you so much for inviting me back here. At an event designed to encourage thought and discussion about the jury, the civil jury, as a political institution, I would like us to remember that the civil jury is part of a larger jury family, a family of political institutions. So what I'm going to talk about today is what lessons we might learn if we think about the jury family. Senator Whitehouse said blank jury, and he mentioned that some people put in runaway. Well, the idea of blank jury, we could talk about civil jury, grand jury, criminal petit jury. There are a family of juries. Now, once you start to think about the family of jury trial, and some of the history lesson that he has given to you is specific and unique to the civil jury. Some of those quotations from history revolve around juries more generally. So, what might the civil jury have to learn from grand juries and criminal petit juries once we understand the jury family? Here are maybe a couple of thoughts. One, the grand jury is a sitting body. It's not as ad hoc as the civil jury, which basically is each one is summoned into existence for a specific case and then dissolves. That's not true of a grand jury. A grand jury convenes, it hears a variety of matters during the course of its tenure. Is it possible, just as a question, that the civil jury has been at a disadvantage to some extent because of its ad hoc quality? Earlier, Senator Whitehouse and I were just briefly talking about the similarities and differences between the House and the Senate. And of course, once one understands that juries are structural, they're a branch of the judiciary, in some ways the lower house of a bicameral judiciary, judge and jury, the analogy of House and Senate becomes not an outlandish one. And the House has less continuity to it. Every 2 years, one house dies, a new one is born. The Senate is a more continuing body, and in that continuity, I think, has certain advantages over the House. And in the same way, is it possible that the civil jury over the course of history has lost out to some extent vis-a-vis institutions that have more continuity and are less ad hoc, institutions like the judiciary or like the bar and other powerful interests. Senator Whitehouse mentioned corporate interests that have more continuity. A corporation never dies. And when we think about the grand jury, we realize that this ad hoc nature, that each jury on the civil side is sort of summoned into existence kind of just for the parties in designer fashion, is not an essential attribute of the jury as such, because there's another member of the jury family that doesn't have quite this ad hoc characteristic. So if we think about the jury family, is it possible to imagine jury reforms in which, for example, we had by law an officer, an ombudsperson, I don't want to say ombudsman anymore, professor, because it was so scholarly. Senator Whitehouse reminds us, an ombudsperson tasked with protection of the jury's interests, as distinct from the judges or the judicial system, to try to soften, to some extent, the disadvantage of the ad hoc civil jury. Each one, you could imagine, is it possible to imagine that a civil jury could actually be summoned into existence and hear a variety of cases over the course of a week or 2 weeks, rather than be picked by the parties for each case? Of course, subject, of course, to challenge for cause if any one of the cases that came before that civil jury happened to be one in which one particular juror or another's participation was improper. So that's a thought about what the civil jury might have to learn from the grand jury. What might it have to learn from the criminal petit jury? Well, maybe this, that there's a role for the civil jury in deciding dispute between two private persons, between, as the phrase goes, and as you heard quoted by Senator Whitehouse, between man and man. But when we recall the criminal jury, we see a particular and distinctive function of the jury in suits between government and man. And one particularly important role that the civil jury need to play, even if it loses some of the power that it had across the board at the founding. I think we'd want to be especially careful about preserving the role of the civil jury in suits between government and man, or perhaps I should say man and government. In a criminal case, the government initiates a prosecution. In one of the very important paradigmatic civil cases, an individual who had been intruded upon by government might sue the government official who trespassed against him in an unreasonable way, committed an unreasonable search or seizure. The Fourth Amendment, you may recall, originally was about protecting innocent people from unjustified intrusion. And the civil jury played an important role, of course, in deciding whether the government intrusion was, in fact, reasonable. A mixed question of fact and law. And even if the role of the civil jury is eroding in other ways, preserving its role in cases between man and government, when government has abused the man and the man goes to court, either as plaintiff or defendant, since I see my friend Ilya here, we could think about just compensation cases. And either when the government is actually initiating a condemnation action against a property owner, or in an inverse condemnation proceeding when a property owner says, you've taken my property and you actually haven't given me proper compensation, is there a role for a civil jury in deciding what compensation would truly be just? A jury composed of people who at one level are going to be the taxpayers whose tax money is going to be funneled through the government to pay for just compensation claims, ultimately to pay for lawsuits brought against errant officials who search and seize unreasonable. So at one level, a civil jury can understand the legitimate needs of government, and on the other side can see themselves as the intruded upon individual and can perhaps sympathize with that man, that person, and be a very good and proper balancer, decision maker. The Supreme Court of late has tended to think that there's that questions of reasonableness in the Fourth Amendment are pure questions of law, not fit for jury determination, but for judicial determination. I wonder about that. And the criminal jury is a reminder that juries do more, actually, than narrowly decide facts. They decide mixed questions of law and fact. On the criminal side, they decide questions of law complicately, which is actually an 18th century phrase. We have a general verdict on the criminal side. They can simply say not guilty. And in doing so, they have a certain policy function, a political function, alongside just a narrow fact-finding function. So does a grand jury, for that matter. It can simply refuse to indict even if the facts permit an indictment. They can just say no, and so can the criminal jury just say no, and that is that. Acquittal. No appeal, no retrial, no double jeopardy, and there are at least questions about whether that more political and policy-soaked law and fact together role of the jury on the criminal side, even if inappropriate across the entire range of civil litigation, might be particularly appropriate, in suits between man and man, might be on the civil side particularly appropriate in suits between man and government, where the jury is designed in part to keep professional government officialdom, professional government officialdom in check. Okay. So much for what the civil jury might learn from other members of the jury family. What might it teach other members of the jury family, other political institutions that are also called juries, but have the same last name, but a different first name? There is, I think, an interesting harmony between the idea of holding the scales evenly between man and man on the civil side, and the idea a mere preponderance of evidence being the relevant standard on the civil side, and the idea that, at least in some civil suits, the juries need not be unanimous. Simple majorities may suffice to do civil justice. Now, what might that tell us about the criminal side? Because here, actually, there's not a preponderance of the evidence standard. There's proof beyond reasonable doubt. The scales are supposed to be designed to favor the individual, the man, against the government, if there is genuine doubt about the man's guilt. Do the voting rules of the criminal jury sensibly reflect that idea? Well, they require unanimity to convict, so okay, but they also require unanimity to acquit. Does that make sense, actually? Is it possible? And once you understand it, you see juries need not be unanimous. Civil juries aren't always. Grand juries, for that matter, don't need to be unanimous either. Lots of political institutions don't need to be unanimous. I'll say it, dysfunctional as the Senate at times can be with a rule of 60. Imagine how dysfunctional it would be with a rule of 100 that were really enforced. And I do know they have unanimous consent, and sometimes they do act as if it's a rule of unanimity. But courts don't have to be unanimous, and the Senate doesn't always have to be unanimous, and the House doesn't always have to be unanimous. And again, grand juries and civil juries need not be. So on the criminal side, is it possible to imagine that we have asymmetric rules for criminal justice, tracking the asymmetric rules of proof? Something like 9-3 sufficing to convict, anything less than 9 counting as an acquittal. Double jeopardy attaches. By the way, that's how impeachment works, to go back to the Senate for just a second, where the senators act as judges and jurors, deciding law and fact, and 2/3 is required to convict, and anything less counts as an acquittal, asymmetrically. So once we start to see the jury as a member of a family of political institutions, perhaps it has something to tell us about criminal jury reform. Why would you ever want to move away from unanimity? It might be necessary as a practical matter to move away from unanimity as we let more people be jurors, because it's no longer man and white man and white man. And unanimity at the founding on juries may have been accomplished by broad exclusions of folks who weren't even able to climb into the jury box. And if we open the jury box to a more diverse citizenry, it may be unrealistic to imagine that juries will always be able to achieve unanimity, just as it's not realistic to imagine that the Senate will always be able to achieve unanimity. Final thoughts. So those were a couple of thoughts about what the civil jury might have to teach other institutions, what it might have to learn from other institutions. Now, just a couple of thoughts about ranging beyond the jury family, narrowly understood, to rethink other political institutions that might learn from the model of the jury. Let's think about voting. You have a right to vote. Do you have a duty to vote? You have a duty. You have a right to serve on a jury, but also a duty, and we enforce that duty. It's a responsibility of citizenship along with a right, and if that's true of jury service, could we think of voting that way? There are other great democratic societies that have mandatory voting. One needn't vote for the Democrat or the Republican. One's allowed to vote none of the above, but voting is a duty rather than a right. In some ways, maybe it makes more sense to enforce a duty of voting than on a jury, because when you serve on a jury, you can make a difference. On a criminal jury today, actually, unless your vote will be decisive today, given unanimity rules, and even in grand juries and civil juries, it's a small enough group, and one person's vote on that body might make a difference. I'm afraid I'm going to say something here that may shock some of you, but because some of you were taught by your third grade teacher that you should vote because your vote will make a difference. It might make a difference. And if your third grade teacher told you that, either she was lying or she never took a basic poli-sci class in college, because here's the truth. Your vote will never make a difference. If it's close, someone counting the votes will cheat. And if it's not close, it's not going to make a difference. That's not why you vote. You vote because you have a duty to vote, because you have a responsibility to vote. Do you refrain from committing murder because you might get caught? Or do you refrain from committing murder because refraining from committing murder is the right thing to do? And so is voting, and so is serving on a jury. But precisely because, actually, there are fewer intrinsic rewards of voting than in jury service, maybe we should supplement the intrinsic rewards of voting, which are basically just standing in a long line. That's the intrinsic reward of voting, with a duty to vote. And this becomes less preposterous, less foreign sounding, less Australian, if you will, once we see that actually we do this on the jury side, just the entire jury family. If you have a duty to vote, and here I'm coming to the end, do you also, see, juries do more than vote. They deliberate. They talk to each other. They listen to each other. Do you have, as a voter, do you have a duty not just to vote, but to listen? Alongside the freedom of speech, is there a duty to listen? And if so, how might that be enforced? So maybe before you vote, you actually have to hear the arguments on both sides. And that's your duty as a citizen. Now, voting is no longer a 10-minute proposition, or if you're in Florida, a 6-hour proposition. It's maybe a day-long proposition, more than a day-long proposition. And so here we come, for example, to a proposed reform. It's in the jury tradition that before you vote, this is building on the work of Professors Ackerman and Fishkin. In some ways, I think it has some family resemblances to some of the work that Professor Lieb has done. An idea of deliberative democracy, in which actually people listen to each other, speak to each other, learn about the issues, and then they vote. So you're summoned a week before the election, just like jury duty, and you show up and you listen to the arguments on both sides made by the candidates. There's this amazing thing called television. You can videos. You can actually hear the candidates for different offices making their pitches back and forth. And then you sit around a room with fellow Americans and you actually talk about what you've just heard. And that's a day. And because it's a day, you should be paid for your time, just like you are in jury service. We make it a duty to do that. And you actually listen to each other and you talk to each other. Now, and again, I'm coming here to a close. That model, which is a jury model, and maybe because people just tend to live with alongside folks who are very like-minded. This is the political science work about the big sort. Maybe we actually hook up juries in different, electronically, through Skype and other things, juries from different districts, one red, one blue, and they actually talk to each other a little bit the week before the election. Just ordinary people talking to other ordinary people about their common political life. See, because right now, when ordinary people talk to other ordinary people, here's what the discourse is. Will you have fries with that, sir? That's what citizen discourse is in America today. Will you have fries with that, sir? And it's hierarchical and it's not political, and that's not a self-governing society on the model of the jury as a political family. So So if we came to what I just suggested, which is not really my idea, it's Ethan Lieb's and Bruce Ackerman's and Jim Fishkin's, this is taking the jury idea, the idea of the jury family, and enlisting it in the name of maybe one of the biggest challenges of our era, which is campaign finance reform and anti-corruption. You see, because you can't bribe all the jurors, all the citizens. Okay, and their secret ballot. You can give them money and they can still vote for whoever they want. But our elections right now are dominated by money because people are ignorant, because they're only getting their information in these 30-second sound bites. Now, you have a thing like Deliberation Day on the model of the jury where it's a duty and you have to show up and you have to listen and speak and you engage other folks. Now the 30-second ad doesn't buy you nearly as much because actually between that 30-second ad and Election Day, we have juries across America thinking about their common political life. This is anti-corruption. Remember what Hamilton said, the jury is an anti-corruption device. So it might seem we've come a very long way from the idea of the civil jury to this Democracy Day, Deliberation Day idea, but I suggest to you that if the deep idea of the jury, the civil jury, is that it's a political institution, let's think about our other political institutions. If a deep idea of the jury is that it's fundamentally democratic, it's about people power, let's think about people power more generally. And if the deep idea of the civil jury is that it is, well, civil, can we think about other ways of making our politics more generally, well, civil? Thank you very much.
Thank you very much, Professor Amar, for that very interesting contextualizing of the civil jury in the context of larger political institutions. Now, we have a little more than 20 minutes left in this first session for question and answers. So the floor is open for anyone who would like to pose the first question. And if I don't have any volunteers, I'll call on someone, but I have a volunteer, so away we go.
Senator Whitehouse, I really enjoyed your markdown. Very, very interesting. I'm a jury researcher, and I have really benefited from federal funding of research on the civil jury and the civil justice system more generally. But some of the institutions, like the Bureau of Justice Statistics, for example, have now limited their work on civil juries to pay more attention to criminal juries, criminal justice issues. Can you comment on that? Are you?
No, I wasn't even aware of that. I mean, the logic is that, as Professor Amar said, the criminal case is state versus individual, and the average civil jury in the ordinary case is individual versus individual. There are times when the state's usually the defendant. And so the Bureau of Justice Statistics may feel it has a keener institutional interest in those cases in which it is virtually certain to be a party. But beyond that, I can't think of a reason for it, and I suspect it's just things have to go over the side when the budget gets smaller, and so things that are good get thrown over the side because there are things on the deck still that they think are better.
Well, I'm just saying that without research at the federal level or federally sponsored research, I think we're going to know less and less about how the civil jury in particular is functioning and whether or not, in fact, we need to be concerned about it in any way.
Yeah, well, the good news is that a considerable number of the decisions do get reported. There is an appeal taken, and there is a body of law that develops around them that doesn't, it's not an aggregating type of thing, but it does allow, I think, trends to be picked out pretty clearly, particularly when you see these changes in the law that affect the jury that the Supreme Court in particular is imposing.
Yes, Ilya.
So, of most other liberal democracies, including many in Western Europe that people on the American left often look to as models in some respects, either don't use civil juries or at least make them much less use of them than we do. I don't think this necessarily tells us much about what's the correct interpretation of the Seventh Amendment or like, but does the fact that these other liberal democracies don't do this and that, of according to a lot of studies, their civil justice institutions are, by various measures, at least not less fair than ours, and many actually are better than ours. Does that give you any pause in your enthusiasm for the civil jury at all?
Maybe I'm the creature of my custom, but it doesn't. I'm not expert on the Napoleonic Code and system. If I were from Louisiana, I might have a better idea. But there are a number of safeguards that have been built into those systems over the years. But I think the civil jury was thought of in a uniquely political way when we set up our country, and that to disable or diminish that one element in the constellation of elements of separated powers and rights that creates our American system of government risks creating more harm as it kind of cascades into those other areas, because an essential piece is no longer missing. And I don't know whether on the European side there's a kind of clearer firewall between what is civil justice between individuals and what is government. We've got them wrapped, I think, together perhaps more closely. So I don't think that the fact that the civil jury is less important, presuming that to be true in Canada and in European countries, is any reason not to be concerned when it's diminished or degraded within our system, where I think it's a pretty important core component.
The two key words that you just heard were our system. On system, precisely because their systems are generally different than ours, the functions that in America are served by juries may have compensating counterparts that in their systems, they have completely different systems than ours, so it's not so clear we could just emulate them in this one regard of no juries and we'd be better off. On our, you've just heard one American exceptionalist, and I am another. So here, as a comparativist, would be my invitation. It's the last in, this is the basic theme of the last chapter of the new book, America's Unwritten Constitution, which I haven't plugged in the last 5 seconds. So, and David's very kind to have mentioned. The last chapter is called, because what is an unwritten constitution? Just making stuff up, Professor? Well, one chapter is the Constitution still to be written, the unfinished Constitution, what amendments actually might follow, and I have some tests for what amendments actually would make sense. One test is both parties, as a practical matter, are going to have to favor an amendment, and I think amendments actually should add to liberty and equality, because all the ones thus far in America have, except for prohibition. But my third is states, as a practical matter, have to have road tested certain ideas. America is a family of constitutions. There are 51 of them, state and federal, and they all have a lot in common. Written constitutions, 3 branches of government, 2 parties, single-member districts, bicameralism except in Nebraska, judicial review, juries, separate bills of rights. I could go on, governors who look like presidents. There's actually an American system, and I think it's interesting that the jury is a prominent feature not just of the federal Constitution, but of 50 state constitutions, 50 state experiments in democracy, and precisely because the 7th Amendment hasn't been incorporated and constitutions are pretty easy to amend, this has been a choice rather than a federal mandate, and I think that's just a lot of data and evidence that here in America, this is how we do things here, and it's a very deep part of an intrinsic element of our system.
Yes.
So, Professor Amar, so just staying on the theme of our system, the one part of our system historically, the core design feature of the jury, the whole family is that it's a draft. As you pointed out, that there is descriptively in our system an entrenched difference between privilege of children and duty and responsibility to serve. Both hard fought, both overcome consider whether our system had, at least things have changed or we simply have gotten it wrong, and that these design differences between recruiting jurors and recruiting voters, we ought to change this to require people to vote. And I just want to ask about that. I thought one of your arguments was there's an anti-corruption rationale as where there were money by having deliberation. But one of the reasons we haven't done that is that there is a moral reason why we don't see a convergence. That we don't expect jurors to mobilize. We don't expect them to march. We don't expect them to have slogans. All of the behavior that we take for granted in voters would be wholly out of place in the jury. And that seems because there's an important difference between the deliberative elements of the jury and the way in which self-interest and voting are more tethered, more rightly tethered. And it would be harder, it seems to me, to unmoor the voting model from the legitimate mobilization of passion, emotion, etc. We're all a jury having a deliberation there. That just, I don't descriptively recognize that as our model.
It's very thoughtful, and I wouldn't want to have a federal, very thoughtful. I wouldn't want to have a federal mandate of voting unless counties or states actually road tested this first, showed that it worked here in America as part of our system. I'd like to see maybe one or two jurisdictions try this out, California or just because I'm looking at Ethan because he used to be there, and California tries all sorts of stuff. Now, other democratic societies do have this, so I don't know if it's just in the nature of voting that it has to be voluntaristic. You also said one other thing, we vote our interest, and you're not supposed to do that quite as a juror. There are two different ways of understanding secret ballot. Sort of one is like it's no one else's business and it's just mine. I can vote for any reason, howsoever prejudiced. But there's a different understanding why we have secret ballot. No, I actually have a duty to I'm a fiduciary as a voter for the larger interest. I'm not supposed to simply ask what's good for Amar. I'm supposed to ask what's good for at least Connecticut and maybe what's good for America when I vote. We have secret ballot for second best reasons having to do with force and fear or corruption, so that if someone is actually threatening me, I can cast what I really do sincerely believe to be in the public interest and not be harmed for that. Someone can even bribe me and I can take the bribe and still vote my best interest. And so bribery just dries up because it's not effective in that way. So I myself don't think that voting is just about my interest, and I think a lot of voters do. But thinking about this alongside, because you don't think that on the jury, you're right. You add one more thing, which is political parties do complicate things. We don't wear our party labels on our sleeves as grand jurors and civil jurors and pettit jurors, and we do as voters. And so it's a very thoughtful comment.
Professor Hamilton.
I had a question for Senator Whitehouse and also one for Professor Amar. I might have squeezed them both in. And my first question.
I'll try not to filibuster.
I don't know. I just wanted to just suggest maybe that history doesn't actually support the notion that the civil jury is particularly central. Instead, right, the criminal jury for certain is central when the government brings its power to bear against an individual. But we seem to care much less about juries when we've got private parties involved in litigation against each other, right? And right, the trajectory of history has shown that right, civil trials are increasingly rare, and the Seventh Amendment does not guarantee a jury in every civil trial, right? Only in suits that would have been brought at common law. And so even in that tiny subset of cases that go to trial, a subset of those are, right, would be entitled to a jury if one of the parties requests one.
I think you're correct that the criminal jury has a more important prophylactic government function in limiting the power of government to impose its will through the criminal law on ordinary citizens, which for a long time through the Star Chamber and other devices was a mechanism for forcing political compliance. And it was something that we wished very much to unhinge so that the law enforcement function and the political function no longer corrupted one another. And that is an essential function. There's no doubt about that, and the criminal jury is specific to that. But if you read back through this history over and over again, it's the civil jury that keeps popping up as a means for bringing people into a form of decision-making, as a means for communities to be making decisions, as a means for implicit nullification of laws that are inappropriate, and frankly, as a means of having people have some place they can go where their judges are people from their community who are less likely to have, institutionally, not in every case, but less likely to have the biases of the power structure of the time. So when I see a Supreme Court that is willing to say that a civil jury is wrong in assigning significant punitive damages when the wealthiest and most powerful corporation in the history of the world sends a drunk ship captain out to dump hundreds of thousands of gallons of fuel in a wreck into a pristine environmental area, there's more, in my view, going on in that than just private parties sorting out their own business. And so that kind of gives me the sense that there really is something to this, because what you're seeing is the pushback from power about the disruptive effect of ordinary people saying, you know what, to hell with that, we're done with it. And if you're the big polluters and you've got the legislature pretty well greased, you've got all sorts of folks all over the Whitehouse, anytime somebody tries to move a regulation, you've got your whole apparatus for gumming up that system and flooding it with your point of view and trying to make sure that you can influence it as much as possible. And you see this jury out there, 12 people, or fewer in the case of a civil jury, can just sit down on their own and pound you. That is a disruptive force that I think people in the power structure want to see tamed. And I think that an untamed civil jury is a good force in our country and has the emblem of hundreds of years of history.
John Beth?
She had one for.
Oh, yes. You have another question?
Can I squeeze in?
Sure.
And I said I'd be short.
So just with respect to your proposed reform, which I like the idea of, but does it change your mind at all that even though, as you say, most voters are ignorant, but
Ilya loves it when you say that.
that's
his theme.
But nonetheless, ignorant of political facts, of the structure of government, etc. But studies also show that nonetheless, they vote correctly more than 80% of the time, correctly being defined the way that they would have voted had they had full information. And so, doesn't a reform like yours do not, yes, it performs an education function, but in terms of actually changing policy, changing votes, it really wouldn't result in much, if any, change at all. And so I guess it's sort of a pro-ignorance.
It might not. 20% sounds like a lot to me. Actually, I defer to Ilya now.
80% is a much higher number than most studies show, plus the voters' knowledge or ignorance does affect not just how they choose between candidates, but which candidates get put forward in the first place.
Yeah, so I think it might have all sorts of interactive. I'd like to see the demonstration. I think there's some very interesting data from British Columbia on deliberative jurors. On the question that you asked the senator, the entire Bill of Rights actually emerged. It was proposed at Philadelphia. The whole debate was about civil juries. Hamilton in Federalist 83 actually says this is the thing that's had the most traction is civil juries. If you email me, I'll send you an amazing student paper that I'm actually just been reading by Lachlan Shelfer, all about and it was kind of surprising to me just how much of the jury conversation actually around the ratification of the Constitution and the ultimate adoption of the Bill of Rights revolved around the civil jury, way more than anyone looking at 21st century America would imagine. So if you email me with his permission, I'll send you this paper, which I think is really amazing.
My question will follow on David's first. 60 seconds to set it up. I think when you look at the Seventh Amendment right to jury trial, you also have to look at in the context of the First Amendment right to petition. The fundamental right to sue private parties. And Marshall called a government affording that one of the first duties of government. So we tend not to think about it in the same way we think about the other Bill of Rights with Children of the Enlightenment. We think about restrictions on governmental power. But that petition clause is really an expression of the social contract, why we came together in the first place, so that we have the right for private redress. Your cows are eating my corn. That's why we came together. I want a government that can do something about it. And you couple that with the jury right. And that right to sue is more explicit in most of the state constitutions, the jury rights there, the state constitution. So these are fundamental parts of the American system you're describing. And I have described those two things together as a purposeful constitutional check on private power. Not simply a constitution, the usual thing we think about with the Constitution as checks on public power. And I'd be interested in both of your reactions.
Yeah, I think you're right. You may actually be the author of an article that I remember reading, quite a lengthy one, that makes that point. In which case, congratulations, because it's a really terrific article. But there's a procedural element to the jury and a procedural value to it. There is a restriction of government value to it. There is a restriction of private abuse of government power element to it, and those seems to be the ones that we favor the most. And the thesis that you're proposing is that there's also in the same way that somebody being maimed was an offense against the crown because they were no longer able to, provide work, there was a reciprocal, which was that in your house, in your castle, in your physical integrity, in your life, your liberty, and your pursuit of happiness, you had certain rights that the state was actually obliged to protect of yours against a third person. And so it's not all individual versus state. There's this one place. And I think the jury helps with all of that. But you're correct in pointing out that that's, I think, an overlooked function in all of this, and that we have almost adapted ourselves so much to it that we no longer credit it because it's become so much part of our common consciousness.
I think we have time for one more question for this session. Yes.
I want to get back to the historical and you talked about the role of the jury at the time of the founding. Does it matter that the kinds of cases that the jury was being called upon to decide at that time would probably have been largely property matter cases, and that the members of the jury effectively were restricted to property line? Does that have any implication, this sort of thinking forward historically to the role that we see in the jury today?
So one very interesting element of America's unwritten constitution is how we think about the gravitational pull of later amendments on earlier practices. This is especially complex because we add our amendments to so many postscripts rather than reword processing the original document. I think one of Madison's phrases was like a careless written letter with so many PSs and PPSs. And a cynic might say, isn't it interesting At the very moment that you actually open up the jury to unpropertied people, to black men, to women, you actually, the powers of the jurors are basically increasingly drained away, and this seems a little sinister to a cynic. There is a different way of thinking about the whole American narrative. I say, because of the 19th Amendment, women get to run for president and vice president, even though the 19th Amendment doesn't say that in so many words. And Article 2 says he, him, his. And after the 19th Amendment, Sarah Palin gets to be vice president, and Hillary Clinton gets to be president, and no state could prevent that. And I say, because of the 19th Amendment, women have to be equally on jurors, even though the Supreme Court doesn't actually get around to saying women have to be equally on jurors until 50 years after the 19th Amendment, and doesn't really mention the 19th Amendment in these cases, in Taylor versus Louisiana and Hoyt versus Florida and other state courts. Actually, half of them do recognize the significance of women's suffrage from women jury services. The question of conscription, even the phrase was brought up, a draft, let's think about the military. And we still haven't fully vindicated a 19th Amendment, where I think a 19th Amendment will mean that women have to be actually eligible, draft eligible, just like men. And eventually, when women are draft eligible, just like men, that will feed back into our elected politics. So instead of having senators like John Kerry and John Kennedy and John McCain and Bob Kerry and Bob Dole, you'll have Joannas and Robertas, as many as Johns and Bobs, and so these things. So that's a different narrative. That actually the increasing inclusion reflected in the amendments actually should add to populism rather than drain it away. But it's this very interesting question: how do we think about the gravitational pull of later amendments?
Well, thank you very much, Senator Whitehouse. We're very pleased you were with us today. We wish you well next week as you sort out the sequester here in the United States Senate. We know
We
you're
need
up to the task.
all your prayers. Let me say one thing before I go, though, because I do know people in real life who actually were elected by one vote.
Oh, okay.
And in addition to the one vote decision on your own behalf, particularly speaking to a group of students, as part of a generation or as part of a interest group that is not connected in time but is connected by some other loyalty, it makes an enormous difference whether you show up or not. And I think the last 3 elections prove that in a very, very big way. So I know that Professor Amar was making that point to pique you and to get your attention, and it was exaggeration for purposes of argument, but I can't let it go because you can in fact win an election by one vote. Granted, it's going to be a local election, and particularly students' decision whether to vote or not tips the balance in this country as to where we go.
Thank you, Senator, and thank you, Professor Amar. A wonderful beginning to the conference, and we now have a break, which I believe is about 7 minutes. Is that right, Jason? So we will take a quick break in the hall, but we're going to start again at 3 o'clock. Thank you very much.